Colonialism may be a thing of the past, but Africa's legal systems are still shackled to it. What if I told you that the laws we follow today were never meant for us? It's time to rethink, reshape, and reclaim our justice system to truly reflect African values. Let's explore why Africa's jurisprudence needs an overhaul and what that will mean for our future. Join me as I dive into the controversial challenge of rethinking Africa's legal systems and see if we can come up with a better alternative to colonial rules. Welcome to Inkari. It's time. In today's video, we are diving into an important conversation about Africa's legal systems. Many African countries still operate under the legal frameworks left behind by colonial powers. The truth is, many African countries are still stuck with legal systems imposed on them by their colonial rulers. Systems that were designed to serve the interests of their colonial powers, not the people of Africa. These systems have been in place for so long that they have become an integral part of our lives. But the question is, are they really serving us well? And now that we have moved beyond colonialism, shouldn't we rethink these outdated systems? Stay tuned as we discuss why Africa's jurisprudence needs a complete overhaul.
Umthetho sizoyishintsha weba kwethu. Umthetho kukhona isizinza somthetho okuyiwona ephethe yonke eminye imithetho. Ibizwa ngokuthiwa mawugwetshwa nje. Ugwetshwa ngumthetho obizwa ngokuthi oyimthetho yase South Africa. Roman Dutch law. Roman Dutch law. Sibuswa ngomthetho wamaRoma namaDashi. Asikaze sibe ngamaDashi thina noma amaRoma. Kodwa sibuswa ngomthetho. Fanele sibuswe ngomthetho wase-Africa. African law, not Roman Dutch law. African law. Lo wethu esiwaziyo onobuqiniso. Awugwetshwa ngoba kuthiwa uhlakaniphe kakhulu ngaqaba kwathi uqamba amanga. Khuluma nje iqiniso. Zokwenza njalo.
As the MK party, we are interested in genuine and real transformation of South Africa. This cannot simply mean having a nice, toothless constitution or so-called world's best constitution. We are not and can never be satisfied with our judges regurgitating Roman law, which was imported into this country through the genocidal force and forced down our throats. When we were colonized, we had our own systems of justice in place. African customary law, which is close to our heart. Colonization brought with it a foreign legal system, Roman Dutch law, and this was done in order to protect and preserve the interests of those who colonize us. I challenge you to tell me a single country in Europe which is governed by African law. A single country in Europe which is governed by African law. If you can't tell me, why do we allow Roman Dutch law, which does not reflect the views and the aspirations of the majority of the people in this country? Why do we allow that to be a system in place? Why? The conclusion is inescapable that legal system is there to preserve the interests of the privileged white minority in South Africa at the expense of millions of poor black people that we represent in this parliament.
Most African nations inherited legal systems from their colonizers, such as English common law, French civil law, or Roman Dutch law. These systems were designed to serve the colonial administration, not the local populations. They ignored African traditions and values, leaving behind a legacy that many feel is out of place today. African nations face numerous challenges due to these outdated colonial laws that are unable to meet the needs of modern society. One major issue is that these laws were designed to maintain the power of the colonial rulers, not to promote equality and justice. They often prioritize the interests of the elite over those of the common people, exacerbating social and economic inequalities. Furthermore, these laws are inflexible and slow to adapt to changing circumstances, making it difficult for African countries to respond effectively to emerging challenges. Long before colonization, African societies had their own systems of governance and dispute resolution. Customary law played a central role in maintaining order within communities, but colonial systems marginalized these traditions. While some customary law is still practiced, it doesn't have the same weight in the formal legal framework. Another challenge is that colonial laws often contradict traditional African values and customs. In many African societies, traditional dispute resolution mechanisms were based on community involvement, negotiations, and restorative justice. However, colonial laws introduced a more adversarial approach, emphasizing punishment over rehabilitation and reparation. This has led to a disconnection between the formal legal system and the values and norms of African communities. Additionally, colonial laws have created a power imbalance in many African countries. They often concentrate power in the hands of the ruling elite rather than distributing it among the people. This has led to a culture of impunity, where those in power can act with impunity, while the marginalized and the vulnerable are left to suffer. The lack of accountability and transparency in these systems has also contributed to widespread corruption and abuse of power. The consequences of these outdated laws are far-reaching, affecting every aspect of life in Africa, from housing and land rights to women's rights and access to education. Colonial laws are hindering progress and perpetuating inequality. These laws, they must just go.
As official customary law. But the position is this: whichever customary law you look at it, whichever customary law you look at, it is oppressed by common law, which is foreign law, which is Roman Dutch based. So whichever way you look at it, the bottom line is that when you remove when you take away the foreign law, which was forced down our throat, which is in the form of Roman Dutch law and English law, you will be left with pure African law, whether it is living African law or whether it is official customary law.
First president of the ANC is Langal Malele Dube. He gathered the kings after the Land Act was passed on the 19th of June, asking kings, do you like this law? They said, we don't like this law. They contributed money to say, go to US, go to Britain, Portugal, France, and tell these powers to say we don't want this as kings. The law of jurisdiction does not allow that a foreign law be used in a foreign land. So it is illegal. It is illegal that the Romans and the Dutch and the British and the French and the German and the Spanish and the Portuguese to come here, practice their law here. This is not Rome, this is not Dutch, this is not Britain, this is not Portugal. This is African. But our judges, our justices, they are good at applying a foreign law in a foreign land. And they are saying nothing about it. It's wrong. My lot is stolen from a king who presided in his traditional council and judging his matters. You say my lord because you are referring to a landlord. He had judicial powers to judge over his land. Where is the authority to judge matters of the kings today? They say kings' judgments are no longer admissible in court. Which court are you talking about? The Western court. Okay, fine, we don't need it anywhere. Where is ours? Our powers were usurped.
Africa faces unique challenges today: land disputes, economic inequality, corruption, and human rights issues that colonial laws were never designed to address. How can we expect legal frameworks created over a century ago for foreign rulers to solve these modern African problems? We need legal systems that reflect our realities. In countries like South Africa, the apartheid-era laws still influence the legal systems, perpetuating racial and economic inequalities. In Nigeria, the Colonial-era Land Use Act has led to forced evictions and displacement of communities. In Kenya, the Colonial-era Penal Code has been used to criminalize LGBTQ+ individuals. These are just a few examples of how colonial rules hinder justice and equality in Africa. The case of Malawi is particularly striking. In the 1960s, the British colonizers imposed a law that prohibited small-scale farmers from growing certain crops, forcing them to focus on crops that would benefit the colonial economy. Today, this law still exists, restricting the ability of Malawian farmers to innovate and respond to changing market conditions. In Tanzania, the colonial-era forced labor laws have been used to justify modern forms of exploitations, including child labor and trafficking. The laws have also been used to suppress labor movements and stifle workers' rights. Our legal education system is another area that needs attention. Many African lawyers are trained in Western legal principles, with little exposure to African customary law or African legal philosophies. It's time to rethink how we train legal professionals so they can serve Africa's unique needs. Replacing colonial legal system with more culturally relevant and modern frameworks could have numerous benefits. For one, it could lead to a more inclusive and participatory approach to governance, where the voices of ordinary people are heard and valued. It could also promote more effective and responsive governance, as laws will be designed to address the specific needs and challenges of African societies. Modern legal frameworks could also facilitate greater accountability and transparency, reducing corruption and abuse of power. They could promote greater respect for human rights, particularly for marginalized groups such as women, LGBTQ+ individuals, and minorities. Furthermore, culturally relevant legal systems could help to revitalize traditional African values and customs, promoting a more holistic approach to justice and dispute resolution. They could also provide greater recognition and protection of indigenous rights, including rights to land, natural resources, and cultural heritage. The African Union could be a key player in shaping a more unified legal identity across the continent. By creating frameworks that prioritize African values, the AU could help countries cooperate on cross-border legal matters and advance human rights from an African-centered perspective. In conclusion, It's clear that Africa's legal systems require a radical overhaul. We need to move away from colonial rules that prioritize the interests of the elite and towards a more inclusive, participatory, and culturally relevant frameworks that promote justice, equality, and human rights. By moving away from these outdated colonial frameworks and embracing our own traditions, we can create a justice system that truly serves the people. The time has now come to rethink Africa's legal systems and create a better future for all Africans. The future of African jurisprudence lies in integrating modern laws with African values and solving Africa's unique problems. Thanks for watching, and I would love to hear your thoughts on this topic. Please leave a comment below with your opinions and suggestions for how we can create a better legal system in Africa. And if you want to learn more about legal reforms in Africa, be sure to check out my other videos. Don't forget to subscribe to Inkari, It's Time, and turn on notifications so you don't miss our next video. Together, let's continue the conversation on Africa's future. Thanks and take care.